Bosco Ted Braham.
Morning, Judge. He's on Zoom for the discovery hearing.
Sir, you need to start your video.
There we go.
Am I here?
All right, thank you. Thank you for dressing appropriately for court. All right, Norma, set this for jury trial at the end of August.
Yes, ma'am.
Thank you, Your Honor.
Okay. All right, August 25th will be your jury trial date. And counsel, if the records are not in, of course, we'll proceed accordingly.
Sounds good. Thanks,
Thank
Judge.
you. All right, sir, you'll need to be in court on August 25th.
Yes, ma'am. Thank you.
All right, thank you. Have a great rest of your day.
You as well.
All right, Ariana Teresa Lene Napoleon. Hello.
Hi.
All right.
Oops.
So where are we on discovery?
Judge, on the CTV side, I see an email talking about audio, so I'm double checking with the agency that they can send me the audio, and then also inquiring about surveillance that may or may not exist. It doesn't make mention in the report. There's also an unindicted family violence case I have in front of second. So we can just have one recess, like security and stuff.
All right, Ms. Ferguson, I need a 45-day reset for discovery.
Yeah, August 24th.
All right, August 24th, just have a seat. Once you sign the reset form, you'll be excused.
Have a seat.
Oh, okay. Sure. You're welcome.
Thank you, Judge.
You're welcome.
Afterwards, may I be excused?
Yes. What's the person's name?
Mahmoud Ogadrov, Your Honor.
He's on page 1, there's 4 down.
All right, on this case, counsel, what is happening?
My understanding is that Mr. Ogadrov is still in custody out in Hardin County.
The last time you were here, you said that you all think maybe you've worked something out.
There was a renewed offer that was made on this case that I believe my client may be possibly interested in. But with him being out of county, I've not been able
I
to.
mean, have you talked to them in the other county?
No, ma'am.
All right, where is he?
Are you asking me or, oh, sorry, Hardin County. Or Hardin, is that right? No, I'm sorry. It's a small county, Judge, I'm sorry. I believe it's Hardin County.
How do you spell that? H-A-O?
Hardin? Correct, yeah, that's it, Judge.
All right, have you all called them? Because on their website, it doesn't show that he's there.
I have not called, Judge. For the last few settings that we've been here, he's been in that county, and I know he had active cases in that county.
All right, let me double check it again.
I believe he had about 4 or 5 cases. I'm actually not sure, Judge. I've never heard of any of these towns. I don't know what the county seat is.
Is it Huntsay, Texas?
I believe so. Kuntze, K-O-U-N-T-Z-E. Is that what you're saying, Judge?
Mm-hmm.
Kuntz. I've been anticipating, Judge, because I know, like I said, for the last few settings, you have been issuing warrants, bench warrants for him to be brought back here. And we. Quick request, Judge. Sorry. Is it okay for me to bounce around a couple courtrooms and come back? Thank you.
No, good morning. Good morning, y'all.
And I'm sorry, you said who?
Get after your boyfriend.
Right now. No.
Sergio Rodriguez?
You know what, my work just picked up another.
Joshua Perkins.
Yes.
Good morning, Judge.
Good morning. So where are we on this PTE?
Judge, I apologize. It was my fault. I delayed it. I lost it in my calendar, but it's already been turned in. The application.
All right, so Norma, recall this for final PTD date.
Joshua Blake Perkins.
August 10th.
Thank you, Judge.
All right,
Take it
thank
on.
you. Stay on top of everything, okay?
You got it. Thank you, Judge.
Joshua Perkins. Hello.
Good morning, Judge.
Good morning.
Sergio Rodriguez.
Good morning.
Good morning. So where are we on this case?
Judge, the state has turned over all the discovery to me.
Mhm.
This morning I forwarded to Rick, some mitigating information that I think will resolve this case by the following settings, or resolve both cases, excuse me.
Okay.
So Rick's gonna review it and then hopefully by then or before then, we can resolve both cases.
All right, so when do y'all want this recalled back?
Thank you.
All right, I'll set it for disposition in 30 days. Norm, I didn't need a 30-day reset.
It'll be August 10th.
Okay.
All right, so Mr. Perkins, you'll need to be in person on August 10th, okay?
Yes, ma'am. Also, to my attorney, did you get the email that I sent to you, sir?
Did.
Yes, sir.
All right, and he's in Bear County, right?
What's that?
Are you in Bear County?
No, Judge, he's on bond.
No, Bear County.
Oh, okay. Sorry.
That's okay. You're in Bear County, correct?
Yes, ma'am.
All right, so just make sure you're in court on August 10th, okay?
Yes, ma'am.
All right, thank you.
Thank you.
I was like, what? Jesus Rodriguez Mancada? Yes. All right. So we're supposed to be here for finalization of this matter.
That is correct, Your Honor. So we do have an agreement in place for revocation. The issue is my client's wife has an autoimmune disease. He is just asking for 2 weeks to try and organize some care for her while he is going to be away.
All right. Could you pull the MTR for me, please?
Yeah.
Ms. Abrams, do you have the court summary on Jesus Mancada?
Yes, Judge.
Your Honor, I do have some documentation regarding his wife's health issues if you would like to see that.
Sure. All right, we're going to go on the record. Court is calling 2013 CR 11091 State versus Jesus Mancada. Could I have parties announced for the record? Could I have a file stamp, please?
Trey Maurer for defense.
And are you Mr. Mancada?
Yes, ma'am.
Did you review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jesus Mancada who was placed on community supervision in 2013 CR 11091 for the offense of forgery of a commercial instrument or check on June 27, 2017 for a term of 4 years? Is that you?
Yes, sir.
State?
On state's first amended motion to revoke violated condition number 5 in Bear County, Texas, defendant Jesus Rodriguez Mancada did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2020 in violation of condition number 5.
How do you plead to that, true or not true?
True.
Violated condition number 5 in Bear County, Texas, the defendant Jesus Rodriguez Mancada did then and there failed to report to the supervision officer as directed for the months of January, February, March, and April 2021 in violation of condition number 5.
How do you plead to that, true or not true?
State will waive the remainder.
And that's 3 5s.
2 5.
2 5s. Okay. Did you understand by pleading true to any objections to the waivers?
No objection, Your Honor.
Do you have the court admonishments? Oh, I'm sorry, you gave it to me. All right, did you understand by pleading true to violation of condition number 5 and 5, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $1,500 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violations 5 and 5?
Yes, sir.
Court will find 5 and 5 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement for the court's consideration is to grant state's motion, revoke community supervision, sentence to 1 year, and run concurrent with cause 2026C008026.
That is our agreement, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes,
Are you waiving your right to appeal?
yes.
All right. Probation. Was the restitution paid in this case?
Yes, sir. I'm sorry.
Okay. I know that was before your time when you were in this court. But there is $77 to Twin Liquors, $178 to Gabriel's Liquors, and $136 to Don and Ben's. Have you paid that?
Yes, ma'am. I paid that. I'm sorry, that was one of the things I was going to go on probation. That was one of the stipulations I had to pay before I was put on probation.
Ah,
And my attorney was George Shaver at the time.
let me see. Who's the person who took this plea?
I believe the judge
yeah.
was
Angelina?
Angelini.
Well, I know that was paid beforehand. All right, Ms. Abrams. It was Angelini, so it was paid beforehand.
Yes, sir. I don't have anything on his former conditions or anything that indicates residence.
All right, and you're waiving your right to appeal? All right, the court is finding 5 and 5 true. The court will grant the motion, revoke. This is right concurrent with 2026 CC 008026. And counsel, you're saying that there's some issue with his wife?
Yes, Your Honor. My understanding is that my client's wife does have some healthcare issues, notably an autoimmune disease that requires some care. Obviously, my client is eager to get this time over with and move forward with his life so he can focus on being there for her.
And when you're drug tested today, what will the results be?
Negative.
Okay. All right, the court is gonna sentence you to a $1,500 fine, time and money run concurrent. The court will sentence you to 1 year in the Bexar County Jail under 1244. And I'm only doing that because I have seen the medical records in regards to his wife. I don't know if you're gonna be any help to your wife or if you're gonna take care of her the way you did not take care of your probation, but I've taken that in consideration.
Thank you, Your Honor.
And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition.
Thank you, Your Honor.
If you have a question over what that is, you'll need to speak to an attorney, and they will take you into custody today.
Okay. Thank you, Judge.
Thank you. Good luck to you. Michael Joseph Mora. Hello. Hi, how are you doing?
Doing good.
Hi, you're looking great.
Thank you.
So what's going on?
Judge, Mr. Moore.
Huh?
Mr. Moore is doing very well on probation.
Mm-hmm.
Right now, his probation officer has no concerns. He is seeing his case manager on a regular basis, his provider on a regular basis. He's taking his medications as he should. There was a concern because, Judge, I believe you have him calling in the IVR hotline testing weekly.
Mm-hmm.
There was a glitch in the system where when he called into the IVR hotline, it was telling him that his number had expired. They have fixed that glitch, but he hasn't been able to submit. He didn't submit because of the whole glitch or whatnot. So what we're asking, possibly if he goes submit this drug test and it's negative, that we remove him from the IVR hotline and just place him on monthly random UAs. All of the UAs since his last positive have been negative. Ever since, we've got him in contact with his case manager and all that stuff, all this, the mental health services. So he's under that caseload, he's being monitored, and he says he's doing really well. Got a little overwhelmed yesterday, but he was able to work through that. No, it's the conversation at the table is. So yeah, he's doing really, really good.
That's awesome. So they said you got a little overwhelmed. So how did you address that?
I went home and I don't know how I made it home, but I made it home. and got some air, some water on my face.
And,
Got through it.
and I
Got
think,
through it.
and I'm sorry, I think that was mainly because all of his, appointments were yesterday.
Mhm.
And he said, you know, the stress of trying to call the hotline and it's not working,
Mhm.
it just compounded. So, I talked to his officer earlier today. She said she has no concerns at this time.
That's awesome. And
Thank
that's the way you should handle it. You know, somebody said, if you want to find a good partner, you know, in your life, of course, there are other things like do your background check, but they said the other thing, you give them a computer that doesn't work and see how they handle that. If they're able to be calm and just work through it, then you know you have somebody who's patient. So with the UA hotline, you're just being calm and working through it. I always tell people, if you know you're doing the right thing and there's something else that's happening that's not your fault, it's going to be discovered, because I love to do the investigation and make sure everything is going well. So probation is asking that you be taken off the hotline after you test today if your test is negative. So do you want to do that? Do you think that'll help you? Am I giving you too much room? All right. So if your test is negative, then we're going to transfer you off the UA hotline and we'll do just regular random UAs. And then ultimately, if you're doing well with the regular random UAs, then we can change it to just regular UAs. So continue what you're doing. Is there anything that you need from us that we can help you with? All right. How's life been treating you other than this?
Great.
All right. And is everything okay with the medications and everything?
Yes.
All right. If you have any side effects or something that comes up with the medication, talk to your doctor about it. If you feel like you can't get in contact with them, if it's during business hours, we will be open and you can come here, okay? All right. So when do you want to recall?
Do you think it's necessary, Judge, at this point? Maybe once more?
Yeah, once more. I'm thinking 60 days because that'll give him more time and we can see where it is. I just want to make sure, I already know you're on your right path, but I just want you to continue, okay?
Okay.
All right. 60 days. All right, September 8th. Is that a good time for you? So are you, do you have employment?
Yes, I'm still employed.
Okay, awesome. Are you enjoying it?
It's hot.
It's hot. Yeah.
It's real hot.
Oh, and it's a different type of heat, isn't it?
It's
The humidity.
hot.
Well, please make sure you wear your sunscreen, okay? All right, well, good luck to you and keep up the good work, okay? And we'll see you back on September 8th.
Thank you.
All right, thank you. All right, Marlon John. Hello, good morning. Hey, make sure you're on time though. Okay?
I'm so sorry. I kind of have my dates confused today. My other court in, what's it?
Court 6.
Court 6. So yeah, completely, sorry, apologize for the tired, but yeah, my apologies.
All right. Just make sure you keep up with your dates, okay?
Yes, ma'am. Yes, ma'am.
Because there are other judges, when people are not there exactly at 9, they just issue warrants and, you know, it is what it is,
Roger
as
that.
they
Yes,
say.
ma'am.
All right, so Mr. Munoz, I know you were recently appointed.
Correct, Judge. Yes, we did have a chance to review the discovery.
Mhm.
As it stands, it seems like there might be some code ban outstanding. I brought that to the attention of the state, so they're going to go ahead and request that additional video, Judge.
Oh, nice. And did they give you an idea when that will be?
I talked with the prosecutor. We're more so aligning that we believe 30 days around that time should be sufficient, Your Honor.
All right, and where do you see this case going?
I won't have a good sense, Judge, until I have the chance to review everything.
All right, Norma, I need a recall for discovery in 30 days.
Would the court be able to do August 13th on a Thursday, Judge?
Norma, August 13th?
Sure.
All right, we'll see you back on August 13th. Once you sign the reset form, you're excused.
Yes, ma'am. Thanks, Your Honor.
You're welcome. Have a good one.
Thanks, you too.
Aaliyah Jackson.
No.
I don't.
All
believe
right,
these
is
are
he on a
done.
commercial bond?
I believe so.
Did anybody call the bondsman?
I haven't. I just asked the court if,
All right, y'all want to call the bondsman?
Okay.
Because otherwise I'm going to call this hearing.
okay, I will, Judge. Thank
All
you.
right, thank you. Rachel Beckman.
Hi.
Let's see where we are on this. All right, what is happening with this case?
Well,
Do y'all have all discovery?
no,
What's outstanding?
but to be honest, Your Honor, I've already tried this on the civil side, so I know the facts like the back of my hand.
All right,
So I'm ready to go, except for the fact that I'm going on vacation tomorrow for a week and then I'm having surgery and I'll be out a week from the 20th.
Norma,
Yes, ma'am.
set this for jury trial in August.
Yes, ma'am.
I do have 2 vacations planned in August, so let me tell you what those are.
I can do the 25th, August 25th.
If I leave, I go to Philly that weekend.
All right, when will
Judge,
you be
September
here?
would be better.
When will you be here in August?
Okay, that's easy. Let me see what I have made. 17th, I have the whole week clear.
All right, Norma, if you can set this for August 17th.
Yep.
All right, your jury trial will be August 17th.
And the likelihood of me going is, because I'd like to get this resolved as soon as possible. This is a divorce, Your Honor. We're ready to go.
Okay, well, actually, just 1 second, Norma, let me look at this calendar. So you say you leave on July 20th?
I have surgery July 20th. And so I won't be able to.
Are you here on the 13th? That's next
No.
week?
No, I'm in Seattle. I leave tomorrow it's my birthday Saturday, till the 16th. So I'm basically out for the next couple of weeks. But August is fine because I need to run it by Dr. Speedlin. She's she did the child custody evaluation.
Mhm.
So she's already investigated all this as well.
All right, just
So
1
we're
second.
seriously ready to go.
Well, no, I'm trying to give you all a date.
August
That's
7th.
like yesterday.
Yeah,
So-
I wish, I wish I could. I'd go today if I could, but August 17th is
What
much better for my
What
calendar.
about July 27th?
I can't do any July because since I'm out for 2 weeks, all my family cases got set for then,
What about August 3rd?
going to Pittsburgh. The August 17th is perfect.
Well, I mean, I'm trying to go through the weeks because I want you to have your jury trial as quickly as possible.
Okay, well,
So August 3rd, where will you be?
oh, wait a second. As long as we can be done by Thursday, because I leave Friday.
Depends on you all. So Norma, set this for jury trial August 3rd.
Yeah,
All right, once you sign the reset form, you'll be excused and I'll need an acknowledgement of discovery signed. All right, thank you.
thank you, Your Honor. Is that a 9 a.m. setting as well?
Yes.
Okay, the only thing that would hold me back is if Dr. Speedlin's not available, otherwise we're ready to go.
I mean, you all have agreed to August 3rd, so I'll see y'all on August 3rd. All right, once you sign the reset form, you're excused. Thank you.
Thank you.
Excuse me, State Defense, let's put this on the record real quick. Court is calling 2026 CR 005075, State versus Rachelle Beckman. Can I have parties announced for the record for the defense?
President, Your Honor.
If you could state your name for the.
Oh, Jacqueline Cribble for Rachel Beckman, we're ready.
All right, and for the state? And you're Miss Beckman?
Yes, ma'am.
All right, so defense has requested a jury trial as soon as possible. The defense's earliest date available is August 3rd. The court was open to setting this trial on July 13th. Defense counsel states she's unavailable. The court was willing to set it for July 20th. Defense counsel states she's unavailable. The court was willing to set it for July 27th. Defense counsel states she's unavailable. So the court has now set this case for jury trial for August 3rd. All right, thanks, everyone.
May we be excused?
Yes. Well, once you sign the acknowledgement of discovery.
Yes, Your Honor.
All right, thank you. All right, Norma Oliva. Hello. Good morning. Court is calling 2025 CR 0132334-02, State versus Norma Olivia. Can I have parties announced?
Yes, that's for the state.
Valentina Cocker on behalf of Miss Olivia.
All right, and so we have a court reporter in training. So do you mind spelling your name for her?
Valentina Kogut.
All right. Counsel, have you received all discovery in this case?
Yes, sir.
And did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Olivia, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes,
Counsel, do you waive the reading?
I do.
Did you review the court admonishments? Oh, state, are you proceeding as presented?
Yes, sir.
Did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you're bargaining for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine.
Yes.
Counsel, has your client been able to provide any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and she was.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a $500 fine to be probated. The state recommends deferred adjudication. There's to be a $120 restitution to the Bexar County Crime Lab for testing. Did you understand that to be your plea?
Yes.
State defense?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be 100 hours community service restitution, the DOEP course, random UAs, and a referral to the felony drug court. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, state offers suits exhibit 1 and all attachments.
No objections.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain agreement.
All right. Who is Fernando Lopez to you?
He's a family friend. He's known me since I was in diapers.
All right. So he's older than you?
Yes.
All right. I'm going to order no contact with him.
I haven't had any contact with him.
So how often have you been using?
I've been using it every day, even like on a daily basis, and I've been using it every day.
All right. So we are going to get you the help that you need, because I want you to be clean and sober, because this is not good, okay? And that gentleman who you said has known you since you've been a baby, he's not a friend to you, because he's in the throes of his addiction as well, and he never should have gotten you involved in that, okay? Are you employed? What do you do?
I work for telemarketing and insurance.
Okay. Do you have any children
1-year-old.
or any grandchildren?
No.
All right. Do you live by yourself?
No, I live with my son.
Does anyone have any Kleenex over there? I'm
I have
out.
some right here.
All right, thank you. Thank you. All right. So this is a bump in the road, right? But it's going to be difficult for you, but you still can turn your life around, okay? So it's going to be 2 years deferred adjudication, regular reporting by Zoom or in person. There's going to be regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's going to be a TAP evaluation out of custody, follow all recommendations. I'm going to want a referral to felony drug court. You need to make sure you make all of these appointments, because if you don't make these appointments, there's going to be a violation of your probation, okay? So you say you've been using daily. Have you used today?
No, I have got into a program, I forgot the name of the program, that the PR bond before this month, I recommended me to. They put me on some boxes, but today was my last day with the medication, and I don't have a doctor's appointment till the 20th.
All right. You may need to go to the emergency room when you leave here. All right. So there's going to be a $500 fine probated. Ms. Abrams, can you contact felony drug court and see if they can maybe see her today, just to give her some resources?
Yes, sir.
All right. So I'm going to make sure you get to felony drug court today so they can give you some resources, okay? $500 fine, that's going to be probated. There's a $120 restitution to the Bexar County Crime Lab. There's going to be 200 hours community service restitution hours. I'm going to order sober support meetings. For every sober support meeting you complete, 1 hour will be deducted for your community service restitution. And I'm going to order 1 sober support meeting per week. I'm going to want field visits 1 time per month for 4 months. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And I'm going to do a no possession of firearms as well.
Yes, sir.
All right, so probation is going to speak to you, and then we're going to get you over to felony drug court, because felony drug court will probably have resources to help you with the medication that you're currently on, okay? If you need anything, you need to let us know, because we can't help you if you're not asking, okay? And thank you for dressing appropriately for court.
Thank you.
All right, good luck to you, okay?
Thank you.
All right, who's here on Herbert Lee King?
Judge. Good morning.
Good morning, how's it going?
Good. How are you doing, Judge?
I cannot complain. It's a beautiful day.
Almost the weekend.
Oh, right around the corner. It'll be a while for us because we're in jury trial, so.
Okay.
All right, the court is calling 2022 CR 9434 State versus Herbert Lee King. Can I have parties announced for the record?
State.
And Jonathan Alvarado for the defense.
And are you proceeding on the MTR?
We are, Judge.
All right, are you Mr. King?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Herbert Lee King who was placed on deferred adjudication in 2022 CR 9434 for the offense of burglary of a habitation with intent to commit assault on May 1st, 2023 for a period of 8 years. Is that you?
Yes, ma'am.
State.
Violated condition number 2, on or about the 26th day of November 2025 in Bear County, Texas. The defendant, Herbert Lee King, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
True.
Violated condition number 2, on or about the 12th day of December 2025 in Bear County, Texas. The defendant, Herbert Lee King, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
True.
Violated condition number 2, on or about the 12th day of January 2026 in Bear County, Texas. The defendant, Herbert Lee King, did then and there fail to submit to drug testing as directed by the court. Court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
True.
State will waive the remaining allegations.
No objections.
All right. Did you understand by pleading true to violations 2, 2, and 2, the court can find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violations 2, 2, and 2? Court will find 2, 2, and 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke supervision, and sentence to 6 years in prison.
And what is happening to the number 1?
That is out of county, Judge. It's my understanding he has a hold to be transferred there.
All right. So you're requesting 6 years?
Yes, sir.
That is the agreed recommendation, Judge. The state is correct. He does have a hold out of county. It's in Guadalupe County, and he was brought over from Guadalupe County here and will be returned to Guadalupe County to resolve that case.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court will grant the motion, find you guilty. Thank you, state. Sentence you to 6 years in the prison. Give you credit for any time served. There's to be no contact with Donald Clark and Kiki, K-I Davis. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, do you have the cause number for that case?
It was on the court summary, Judge. The out of county case, Judge.
Does anyone have the cause number for the out of county case?
Judge, I have 26-0170.
Wait,
Yeah.
017.
Sorry. 0170 dash BR dash
E. The letter E.
as extra.
We're so extra. Okay. All right. This is going to run concurrent with 26-0170-CR-E for extra.
Yes.
All right.
Thank you, Judge.
All right. Thank you.
Yeah,
Yes.
Sorry.
No problem. So the county says that they're busy.
Okay.
Is this a motion to revoke?
Yes.
Norma,
Yes.
you're saying that they can have him by Zoom at 1:30?
Well, they said they'll schedule him for the afternoon. They just didn't give me.
No.
You're not available?
No.
All right. So Norma, on this one, they're saying that they can have him on Monday. But we can't do it. They say that they're overbooked or something. Is Monday okay?
It depends on the time. I have a court hearing at 1:45.
Oh, that would be in the morning.
Okay, I could do it in the morning.
All right. All right, Norma, then put it down for Monday.
9:45.
Yes.
And you'll send the Zoom request?
No, CC me down.
Okay.
All right. Thank you. Sorry about that.
Me too.
Yeah.
Monday morning. Okay.
Yes.
May I be excused?
Yes, you may. Theodore Ted Garcia.
Your Honor, I'm pressed on that. Your Honor, you had Mr. Garcia, you authorized him to apply for the Veterans Treatment Court. We're ironing out a few things. He has been admitted, subject to your approval.
Okay.
If possible, could we have a recall to Tuesday or
No, let's do it now.
Wednesday?
If he's been admitted, then he just needs to enter a plea. So let's get it done today.
We also need a representative from the Veterans Court, Your Honor.
He's been down here.
Yeah, I'll get him. He just said to text him when we were ready, but he has been accepted and he'll just need to be on regular caseload until orientation.
All right, let's do it. Thank you.
Your Honor, right now, I believe the offers a 10 of cap opposed.
Oh, y'all just do your thing and I'll take care of it.
Okay,
All right.
thank you, Your Honor.
Linnell DeForest Taylor? Not here.
He's not in custody, Judge, and yes, he wasn't here Tuesday.
No.
He's the fellow that said he was cursed as we were about to sentence him. You asked him, why do you keep doing this? Well, these people been putting curses on me.
Oh, no, I remember.
Okay, yeah. No.
He was supposed to be evaluated. All right. The court is calling. Do you know, is he on a commercial bond or? We'll see what type of bond he's on. It's 2026 CR 006730.
He's on a PR bond.
All right. Court is calling 2026 CR 006730. State versus Linnell DeForest Taylor Jr. Could I have parties announced?
For the state.
For the defense?
Robert Behrens.
All right. This hearing was actually scheduled on July 6th. The defendant did not appear. The court recalled it for July 9th. The defendant has still not appeared and did not answer docket call. It's now 11:11 a.m. Defense, have you had any contact with your client?
I have not, Judge.
And the last time you were here, you actually reached out to his relatives. Were you able to get in touch with them?
His uncle, I haven't tried to call them today. I'd have to look back for that phone number, but I can attempt to do that if you'd like.
Yes, if you'll attempt to do that. And
If I can
for
find
now,
it.
I'll do a judge's warrant and remand him without bond. But if you're able to reach them and they're able to get him in, then the court, of course, will reconsider.
Let's see. Wait, what date were we here before the sixth?
We were here on July 6th.
I meant the date prior to that.
No, we had we had June 23rd. David Lopez Gonzalez. Court is calling 2026 CR 001813, State versus David Lopez Gonzalez. Can I have parties announced?
Florence Smith for the state.
Valentina Kogor on behalf of Mr. Gonzalez.
And are you Mr. Gonzalez? You entered a plea. According to your plea, punishment is to be assessed at 4 years in the prison. The state is opposed to your application. They're taking in consideration 2025 PF 49447 and 2025 PF 49446. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, sir.
Any objections to the PSI or TAP, state?
No, Judge.
Defense?
No, Your Honor.
All right, the state is opposed. State, do you have any witnesses?
No, Judge. Just brief.
Defense, any witnesses?
Just my client, Your Honor.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
David Gonzalez, Your Honor.
All right, you may proceed.
Thank you, Judge. How old are you?
33.
Are you married?
Yes.
How many children do you have?
13.
What are their ages?
23, 22, 20, 18, 16, 15, 14, 12, 8, 6, 5, 4, 3.
Are they all your biological children?
8 of them are.
And what are their ages? What are their ages?
For the biological.
Biological.
The 23, 22, 20, 8, 6, 5, 4, 3.
And are you currently employed?
Yes.
How were you employed?
With local Union 67 sheet metal.
And what do you do?
We do AC sheet metal.
Okay.
Commercial.
Okay. Are you accepting responsibility for your actions?
I am.
Are you asking the court to grant you probation?
I am.
Why are you asking the court to grant you probation?
I have responsibilities. Oh, I messed up. It shouldn't have happened, but it did, and it can allow it to be something that's gonna affect the rest of the kids as well.
And I'm so sorry. Could you speak?
I
I'm
am
having
sorry.
problems hearing you.
Sure, next to the mic.
Why I want the probation, why I'm asking for the probation is, I did slip up. It was something that shouldn't have happened. But as for my rest of my children, I really need to be that role model for them and not allow something like this to happen again.
And have you been on probation before?
Yes, years ago.
And were you successful on probation?
No, I walked out on it.
And how is this time will be different?
I was younger and I wasn't ready for responsibilities, and I'm trying to be very responsible now.
And did you learn the consequences of not complying with terms and conditions of probation?
Yes.
That's the witness, Jennifer.
State.
Hello, Mr. My name is Lorna Smith. I'm a prosecutor at the state. You just testified with your defense attorney that you have learned from your past. Is that fair to say?
Yes.
How can we talk, or how can you assure this court that you've done that when you picked up 3 new cases since the last time you were on release?
It was, like I said, it was a slip up with something that shouldn't have happened. Going through a lot and helping raise kids that my wife can continue to say that it's not mine. I'm still trying to be there for my kids, even my ones that aren't biological. I raise them as my own, and though we have our hiccups in our marriage, I try to.
All right, excuse me. We're in the middle of a hearing. Please do not walk in front of the parties. All right, you may continue.
I'm sorry. I was just different.
And then on the instant offense, the unauthorized use of a motor vehicle, do you remember that date, August 6th?
From last year.
Yes, sir.
Is this the van thing?
Yes.
Yeah, somewhat.
Okay, and you gave a statement to the PSI officer about the event, correct?
Yes.
And you remember advising the PSI officer that it was your son, Luis, that was operating the vehicle, is that correct?
Yeah.
And you said that he had to drop off a backpack, correct?
Yeah.
And do you remember being Mirandized by the police officer on August 6th?
Yeah, I'm trying to remember all that.
And you remember how you told the officer at the time that you were teaching Luis to drive?
I already had taught Luis how to drive, that's why he had learned, but when all that had happened, yes, it was somewhat similar to that.
So why did you give 2 different accounts of the events that occurred?
I can't remember it all because it's been over a while, but yes.
So which is accurate?
He already had learned how to drive, because when we had a vehicle, before all this had happened, he knew how to drive. But at the same time, it's like he can always learn more, and it wasn't something that I should have been doing in a vehicle like that, but that's what it was.
And you understand that wasn't y'all's vehicle, correct?
Yes, ma'am.
So how can you be a good role model to your children when you're having him essentially be a party to this criminal action?
That's why I said like that was something where I slipped up on that shouldn't have did. And because of all this right here, it's like it really opened my eyes to where it's not something I should be allowing for any of the other kids to be going through it as well.
I see. No further questions.
Any other questions?
No, yeah.
Anything else you would like to say?
No, ma'am.
All right, I'll hear a brief argument.
Judge, we're opposed to the application. We ask that you sentence to 4 years in the prison. Mr. Gonzalez has extensive criminal history. He has 3 felony convictions and 9 misdemeanor convictions. Of the 3 times he's been on probation, he was revoked twice, and then once he did successfully complete probation, so I will give him that and see that. However, Judge, he continues to victimize the community, therefore we ask that you deny his application.
Defense?
Yes, my client is 43-year-old. He has a lot of children. He needs to take care of, some biological, some are not. He's married. He's responsible for his family and for his wife. He's employed. he has taken responsibility for his actions and he's pleading for mercy from the court.
Do
To
you
grant
mind if I
probation.
ask your client a question?
Excuse me?
Do you mind if I ask your client a question?
No, yeah.
Why would you allow your son either to learn how to drive or practice how to drive on a vehicle that you know is stolen?
It was a dumb, it was for that day, like, it isn't something I would want for anybody to be doing or.
No, I mean, I know
Advice.
you're saying that now, but I'm like, why would you do that?
At that given day, like, I just had a lot going on, like me and my wife arguing and everything, and it doesn't excuse it, but it's just a dumb mistake that I did on my part. It really is.
I don't think probation is appropriate for you. One, this is a state jail felony, but it's been enhanced.
Yes.
So it's a third-degree felony. You did 20 days in 2002 for an assault. You did 6 months in jail in 2003. In 2006, you did 5 months and 10 days in jail for burglary of a vehicle. And there were 2 of those cases. One was dismissed. In 2006, you did 3 months and 10 days in jail for an assault bodily injury. And that was in May. In December 2006, you did 30 days for a theft case. In 2007, you did 40 days for a failure to ID. And then in 2007, in May, you were placed on 2 years probation for burglary of a vehicle that was revoked. You know, at one time, burglary of a vehicle was a felony. So you only did 6 months for that. 2008, you had an assault case, bodily injury merit. You did 55 days in jail. You had a failure to identify and evading arrest, detention, and driving while intoxicated. Those cases were dismissed because they say you were convicted for something else. And so I'm not going to consider those. 2018, you had a criminal trespass of a habitation or shelter. You did 96 days in the jail for that. 2019, you had an obstruction of a highway intoxication, which means that they proceeded on an obstruction of highway instead of DWI. 2008, you had an evading arrest detention. You did 1 year in the state jail facility. You also had a theft of a vehicle. Those sentences were run concurrently. 2010, you were on parole for an assault, choking, strangulation. You did 8 years for that, and then you were on parole for it. And then you have some assault cases where the complainant waived prosecution. And now we're here for theft of a vehicle and unauthorized use of a vehicle. And according to the stipulations, the person went in the store, they came back, their vehicle was gone. And how old were you when you committed this offense?
Just last year.
All right, and so how old were you last year?
42.
All right. So I don't think you're appropriate. And so the court is finding you guilty. As previously stated, the enhancement is true. Based upon your plea of true and states exhibits 1 and attachments, the court is going to sentence you to the 4 years in the prison, give you credit for any time served. There's a $1,000 fine. There's to be no contact with the complainant. And there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Maybe you have heard one of the TIC dismissals, the other shows closed already.
Thank you.
Yes. I called the numbers I have for his uncle and his mother. There's no answer. I sent them both text messages.
Okay, I mean, well, I've issued the judge's warrant.
Okay.
Number is here now, Judge.
Okay, just give me a second. Let me put this in the system. And what is your client's name? Let me. Zuniga Alvarado.
Good morning, Your Honor.
Good morning. How are you doing?
Pretty good. Thank you for asking. How are you?
Oh, I'm doing great. I cannot complain. Hey, it's Friday Eve.
Yes.
All right. So I've signed the acknowledgement of discovery that you all turned in.
Did we turn one in?
Oh, isn't that what?
No, it was perfect.
Oh, let me see.
Yes, we.
Thank you. All right. Any discovery outstanding?
Yes, I believe so, Judge.
And what is that? CPS records, school records, what?
All
All of it?
All of it. Plus, we're having to get an interview translated because the CW is a Spanish speaker.
Okay.
And there might be some translation issues with how it was reported.
And how long is the translation going to take?
Your Honors, it is quite a long video. I would realistically 3 months.
And has anyone given it to a translator?
No, we just found this issue out today, so we'll be doing that today. But for just for the record, the CPS records are in the file. We don't have any full records needed. But other than that, it looks like the child safe records are what we're going through.
All right, we're recalling this in 30 days to make sure the state has a translator beginning translation. All right, Norm, I need a 30-day reset.
Sure.
We'll be back on August 10th.
Thank you.
Sir, do you have any questions?
No.
No,
that's fine.
All right, thank you.
Yes.
Thank you, Judge.
You're welcome. Isabel Liliana Martinez. So what is happening with this case?
So that's what I want to talk to you about, Judge, a little bit. Ms. Martinez, as you can see by the nature of her charge, she's had some mental issues in the past. She's currently seeing a psychiatrist.
Okay.
Megan suggested maybe we apply for the mental health court, which I think she's agreeable to doing that. But part of the concern is she got accepted to college in Houston. So she's wanting
Accepted where?
Houston college.
Or
College.
college. Oh, what school are you going to?
HCC.
Okay.
So I have the acceptance letter and her course schedule already. She's supposed to start in a month. So I initially prepared a motion with the court to allow her to move to Houston to start that. But Megan was thinking she might not be able to do the mental health court when she lives in Houston. And she's currently seeing a psychiatrist online. She's helping see her psychiatrist.
Like once a month. I see my
I think it's
therapist every week.
every week. Your therapist, psychiatrist once a month.
All right, let's do this. Norma,
Yes, ma'am.
see if we can call Renee Munoz and see if he's available to come back. All right, and we'll see what we can do. Hey, but what are you studying?
Psychology.
Oh, that's exciting.
She wants to go into counseling because some of the things that she's gone through.
Hey, that's awesome. And I'm loving the hair color.
Yeah.
It's hard. Did you do it yourself or have somebody else do it?
I did it myself.
Do you know how difficult it is to do the layers with the different, well, Cindy, you were a stylist.
Yeah.
It is very difficult to do the layers and not get it on other parts, and especially the way you've done it with the side. So yeah, good work.
Thank you.
That was the other career path she's like thinking about doing, Judge.
Oh, yeah.
Cosmetology, as you can tell.
See, you have to tell your attorney how difficult that is. Everybody sees it and they think it's easy, but it's very difficult. And then you're not looking, you don't have eyes in the back of your head. So you have to do that as well. Yeah, good job. Am I right, Cindy? Good job.
Yeah, I wouldn't try to do it to myself.
All right, so just have a seat. Your attorney's going to talk to an attorney who's in mental health court, and we'll see what we can do.
Okay.
All right, thank you.
Judge, I'm going to go to another court, 175th, and I'll come back.
Okay, thank you.
Annabelle Bella?
She's in custody.
I'm sorry, who is it?
Bella?
Motion to set file.
Okay. If I can have, did you file a motion? Do you have a copy with you, counsel?
Richard,
Oh, thank you.
the NPR is attached on the bottom.
All right, thank you. All right, it says Paul Acevedo hired.
I am helping him. I filed my notice of co-counsel last night. It should be accepted then.
All right, and this new number one, is that a misdemeanor?
It is a misdemeanor.
So what's going to end up happening with this motion to revoke?
Paul Acevedo this morning made contact with the complainant. He's expressed to us that he's not cooperative with the state in this. I'm not too sure if the complainant's made contact with the state on that matter. What we'd like to do is, if we can get her out on the bonds, start negotiating with the County Court 7 prosecutor in the state and try and resolve it as soon as
All right,
possible.
let's see what's going to happen. Try to resolve it. We can call it back at 1:30. It would end up saving funds. All right,
Okay.
Yes, ma'am.
okay, all right.
Or we'll come back to 1:30.
Yes, we'll get it taken care of.
All right.
All right, this is recall at 1:30. And I think it's County Court 13, Council. Yes,
You saw her?
no.
She's your judge. She's not dressed appropriately, so.
Oh, so what is it?
How do we handle this?
Oh, when you say she's not dressed appropriately,
Well, the officer specifically.
You just go out a bit.
oh, and that's Ishanae Williams.
Yes, Judge.
All right, go outside and tell her she needs to go back home and come back dressed appropriately for court, and we'll see her this afternoon.
Okay.
And if she's not back here at 1:30, a warrant will be issued. Imani Hastings. Morning. A lot of women today who've been.
I know.
They're pregnant.
It's
Okay.
Pregnant Women Day.
Yes. How far along?
12 months, about to be 5.
Okay, because someone else in this court was pregnant, I read up just in case I had to deliver a child. So. All right, the court is calling 2026 CR 0071498 State versus Imani Hastings. Can I have parties announced?
Lindsay Shaw for Miss Hastings.
And are you Miss Hastings?
Yes.
Counsel, you received all discovery. Did you review with your client?
Yes, ma'am.
Hastings, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes, sir.
Ms. Hastings, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with organized retail theft from $750 to $2,500 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, so you're gonna have to speak up.
Sorry. Yes.
All right. Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not, you need to say yes or no.
Yes.
How old are you?
18.
18, pregnant, and committing crimes. All right, I'm going to ask you some more questions later. Did you understand that if you're not a U.S. citizen, you will be deported, denied naturalization, and reentry?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine to be probated. The state recommends deferred adjudication. This will run concurrent with 2026 CC 010949. Did you understand that to be your plea?
Yes.
State defense?
It is.
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, the felony anti-theft course, anger management, and no contact with the following. Probation, are you ready for the no contact? Court reporters, you all ready? No contact with famous footwear. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
The offer states one.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence and review the same. State, is there any restitution? All right, thank you. You may be excused. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Judge, the court's aware she's 18 years old. She's 5 months pregnant. She attended Holmes High School. However, she did not graduate. I think when she's ready to be out of the jail, but you know, she plans to live with her mother when she can get out, but she's certainly not had an easy life. I think she did want to tell the court, you know, any help that the court might be able to provide through probation and, you know, when she has this baby.
All right, what do you mean by she hasn't had an easy life?
Well, I mean, you want to tell the judge a little bit about your life?
In and out of foster care.
Okay.
And placed different homes, took and out, placed different homes.
So is it best for you to be living with your mom? Because there's a reason you were moved from your mom. That's probably not a good placement. And the people you were hanging around with, those are not good people. The person who's leaving a 7-week-old baby in a vehicle so that they could commit thefts, not a good person. None of these people that you were hanging out with, and when I say not good people, I mean that they were not doing the right thing. You were one of those people not doing the right thing either. You understand?
Yes.
So have you had any drug use in the past?
Yes.
How long ago?
Like in February.
Okay. All right, and the clerk has just told me, so if you could write this down.
Yes, ma'am.
They're having a free diapers and wipes event, so you can go and get diapers for your child and get free stuff for babies there. It's July 11th from 8 a.m. to 2 p.m. And it's at the Family Service Neighborhood Center, 3014 Rivas, R-I-V-A-S Street, 78228. And since it's on social media, I'm sure they're fine with me. You have to call and make an appointment. The number is 210-900-5436. And so it's, they'll give out free diapers, free wipes. You're going to learn with babies. They go through diapers like nobody's business. And if you try to stretch it out and keep them in diapers too long, that's how they end up with diaper rash. Now, my mom, she started out with her firstborn with cloth diapers. So you can go that route too. But
it's a lot of washing.
Yeah. Thank you so much for letting me know about that.
Of course.
All right, so this is what we're going to do. I'm going to sentence you to 2 years deferred adjudication. Ms. Abrams, we'll do a referral to Esperanza Court. And we're going to call and see if they can see you today. Yes.
Her misdemeanor, we cannot plea her on that until Monday, so she'll have to remain in custody.
So we'll do a referral to Esperanza Court, have you remain in custody. And when that is set on your day, if something happens where Esperanza Court hasn't seen her, just come back here.
Okay.
Regular reporting by Zoom. or in person. This will run concurrent with 2026 CC 010949. There's $1,000 fine probated. And yes, it's not best that you live with your mom because that's going to take you on a path you should not be on, okay? And if there's an issue with housing, after you see Esperanza Court, you can come back here, and if there's no objection from either the state or defense, I'll look into my contacts and see who I can call to help with housing.
Thank you.
I'm going to order parenting classes. Once the parenting classes are complete, 100 hours of community service restitution will be deemed satisfied. And I'm going to order the felony anti-theft course. And once that's completed, the remaining community service hours will be deemed satisfied. There's to be regular UAs, proof of employment, or GED registration within 45 days of release. There's to be no employment as a home health care provider or with minors. And no contact with the following: all right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, so here's the thing. You've got a rocky start, and you got a rocky start because you've been through Child Protective Services as a child. But that's not the end of your story. Don't make it the end of your story. That doesn't give you a pass to do what you know is wrong, okay? So from here, you can continue, you can become successful, and then guess what? Other foster children, you can tell them your story and how you overcame, okay?
Yes, ma'am.
All right, good luck to you. I don't see that on here, an attorney named Mario. Oh, Barton. Okay.
I thought you were saying the defendant was.
Yeah.
I was ignoring that. My bad.
All right, so what is happening?
I did call Hardin County Judge. There are 4 indicted cases. They're all set on 7/21 for announced.
And I also checked online, Judge, for the active jail roster out in Hardin County. Mr. Elbazab is still in that county jail.
All right, so are you able to get in touch with his defense attorney?
I can try. I have tried in the past, but I can continue my efforts.
All right, so we know that defense attorney is going to be in court on July 21st, right? Norma? Yes. Are we able to set this on the 21st? July?
Yeah.
All right, so we're going to recall it on July 21st. And you know what I'm anticipating? I'm anticipating that defense attorney there being able to Zoom in here with his client. And then we can probably take care of things. So if you can get in touch with the defense attorney before then and see, hey, when your client is brought over, if he can do a Zoom in here and you guys can talk.
Still good to meet, Judge.
All right, thank you.
Thank you, Judge.
Thank you. Rudolfo Palma. All right, so what's happening with this case?
Your Honor, we've conferred with the state. They've made an offer, whereas the case here would be dismissed for the plea on the misdemeanor. And so we're going to make that happen hopefully in the next couple of weeks.
All right, when is the misdemeanor case set?
It's a pre-file. I don't have that sitting in front of me, Your Honor.
Okay.
And it's Rochelle's case, so I wouldn't be able to find it. Let me see.
State, can you all look up and see when that's set?
For sure.
And then we'll set it together. That way he doesn't have to make 2 appearances.
Yes, Your Honor.
Yeah, we can get.
Yeah. August 13th. August 13th, Your Honor.
All right, Norma, are you able to recall this back for disposition August 13th?
Yes.
All right, I'll see you then, and you can go to the misdemeanor court first.
Thank you, Judge.
All right, once you sign the reset form, you excuse.
Appreciate it.
All right, court is calling 2024 CR 5108 State versus Randy Gallegos. Could I have parties approach and announce for the record? And are you Mr. Gallegos?
Yes.
Counsel, you received all discovery. Did you review it with your client?
We did, Your Honor.
Court will find that the state is in compliance with discovery. All right, it's the court's understanding that an agreement has been reached in this case. Is that correct, state and defense?
That's correct, Judge.
All right, Mr. Gallegos, you were actually in the middle of a jury trial. Jury selection has been completed and testimony was to start today at 1:30. Do you wish to proceed with this case or with a plea, or do you wish to continue with your jury trial?
Proceed with the plea, please.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
I did, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, you're charged with aggravated assault causing serious bodily injury. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I do, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gallegos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. State, the defense had filed a motion requesting a dismissal based upon the fact that they had not received a report from TBAC. What is the update on that report?
Judge, after speaking to TABC, they have no records from that time of any report being produced. Because of that, there's no report to provide for discovery.
Defense?
We never got the report. We were told it existed, Your Honor. We still don't have it now. I would re-urge the motion, but still withstanding that, we're okay with the plea moving
All
forward.
right, so who told you the report existed?
We received a notice that a witness said it existed and that it was created within the 24 hours after the incident, because that's what was required by law at the time.
All right, and who is the witness who said there was a report created?
I believe it's Mr. Rios.
All right.
The complainant.
Peter Rios.
Yeah.
All right. All right, did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, there's $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
I do.
State defense, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it, sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, other than your motion to dismiss, any other motions?
No, Your Honor.
And can someone tell me what is the occupation of Mr. Pete Rios?
He was formerly the general manager of the I-10 high schools.
Thank you. All right, outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 100 hours community service restitution, no contact with the complainant, or IH-10 ICE House, Jennifer Ortiz Zamaripa, the MRT and anger management. Did you understand those are recommendations from the state And the court does not have to follow those recommendations.
I do.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge reference exhibit number 1, including all attachments.
No objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And defense, you're not waiving your right to appeal the request for the TBAC report, is that correct?
We're not, Your Honor, but that is the only objection we have to 3914.
Okay. All right, and defense, with regards to states exhibits number 1 and attachments, the photographs that are attached appear to be screws in the leg of the complainant that are from the injuries he suffered on this night. Are you stipulating that this is serious bodily injury?
We are stipulating to that, and that is our agreement, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. In this particular case, the way the original report and information came in, there was a misunderstanding of my client's role a little bit that night. He was there with a friend. It wasn't somebody he met there. And I think multiple parties thought they were doing the same thing to protect this individual. And the scene that occurred afterwards, I think there's a lot of regrets on both sides for what happened. And that's part of the reason why we ended up in trial. And the plea bargain we ended up with was not the plea bargain we were originally offered. And that is the reason why we did take the resources of the court to start a jury trial and to use that time. And we're thankful for the court making time for us to have this trial to get to this point. And my client has made a lot of changes from the first thing it was that night. So I just wanted to share that with the court and ask that you please follow the plea bargain agreement.
Oh. Are you employed?
I am, Your Honor.
What do you do?
I'm a project manager and an estimator for Dr. Demolition. I write quotes and then oversee the jobs.
Do you have any children?
I do. I have one.
All right, this is what the court is going to do. 6 years deferred adjudication, regular reporting by Zoom or in person, $1,000 fine probated, regular UAs for 3 months with the testing for alcohol. And then after that period time, he can either do regular UAs or the patch. And the reason why I'm doing that, the patch doesn't really test for alcohol. So the first 3 months, that's 3 months for Sean. The first 3 months, it's going to be regular UAs. They're going to make sure that they test you for alcohol. Then after those 3 months, if there are no positive UAs, then you can either do the regular UAs where you come in to test, or either you can have the patch. The patch costs more, but it's less of a restraint on your time. Proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits 1 time per month for 2 months, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. Ms. Abrams, it appears that everybody was drinking heavily. Do you think it should be the MRT or anger management? Do we need either? All right, and then the remaining 100 hours will be deemed satisfied upon completion of the alcohol awareness course. There's to be no contact with Peter Rios or IH10, Ice House, Jennifer Ortiz, Zamaripa. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the pretrial motion that the court ruled upon. Probation, do you want a no possession of firearm?
Yes, Judge.
All right, and there's to be no possession of firearms. All right. Here's the thing. People drink and they drink in excess and they have no idea what that's going on. And what's stated in the stipulations never should have been said. You should have just leave. When people ask you to leave a location that's not your home, just leave. I mean, unless this is some, great place to be at and, it's like heaven. So therefore I need to desperately stay. Otherwise, just leave and you wouldn't even be here. Is there any restitution or no?
After talking with the complaining witness, there is no restitution, but we do have victim impact. Judge.
All right, so there's no restitution, Ms. Abrams. And I'll add that to Odyssey, because otherwise, if you come back, you're going to be asking for restitution.
We have one other item, Your Honor.
Yes.
My client does reside in Harris County, so would ask for permission to transfer. We understand he may have to wait a minute and report remotely in that meantime.
All right, Ms. Abrams, there's going to be a transfer to Harris County. And if they don't do field visits, then they don't do field visits. So my understanding, Mr. Rios, is by Zoom?
Yes.
Okay. All right, Mr. Rios, if you can unmute and start your video, please.
Can you hear me?
Yes, I can hear you. Are you able to start your video or no? If you're not, that's okay. Is anyone going to force him to have his video? All right, you may proceed.
Okay. 3 years and 9 months ago, you deliberately chose a course of action that would result in me being permanently disabled, unable to work, drive, mow the yard, or even walk short distances without a cane or crutches. Most of my time is spent in bed or in a wheelchair. I will never be able to run with my grandchildren, go deep sea or surf fishing again due to your callous disregard for others. Your actions have had a massive impact on not only me, but my family. My son was working 3 part-time jobs and attending college. On top of that, he has to take not only his grandmother to medical appointments, but me as well. I cannot drive. Do you understand that?
Oh, Mr. Rios, I'm sorry, but the accused is not allowed to answer or speak to you.
Oh, I'm sorry. I apologize.
No, that's okay.
I'll continue. These used to be my responsibilities. It should be mentioned, she is in a wheelchair also. This is too much to ask of a young man who should be living his own life. I struggle daily to do simple things, shower, get something to eat due to the pain and the muscle spasms. I endured 2 very painful knee operations, one of which was a total knee replacement. A Dr. Ford told me the best you can hope for is a decrease in the frequency and severity of the pain. My pain management clinic, which I am still having to go to, they told me the pain will never go away. We just try to manage it. I have had to have a genicular nerve block and radio frequency ablation where they literally burn the nerve that carries the pain signals, neither of which was effective. I am maxed out on nerve pain called gabapentin at 3,600 milligrams per day. Also a muscle relaxer, methocarbamol, at 2,250 milligrams per day. I still hurt. My friends and family worry about me. I do not want to talk or see people. I do not want to go out in public. People stare at me when I spasm. On the first floor of the Elizondo Tower, two people stopped and asked me if I needed help due to the muscle spasms. They thought I needed an ambulance. Even after all this time, I have difficulty coming to terms with being permanently disabled. Now I am angry, very angry, and depressed. You tried to force a woman to leave with you and she refused. She was afraid of you. You stated, I am not leaving without her. That's not what a real man would do. Look how that turned out for you. How much has it cost you so far in pain, suffering, and money? I will leave you with this. When a woman says no, it means no. That's all I've got, Judge.
All right.
I wish I could say a lot more, but I don't think it would be a good idea.
All right. Thank you so much, Mr. Rios.
Okay.
All right. Thank you.
Thank you. Bye-bye. I'm going to try to figure out how to close this.
Oh, I'll close it for you. Okay, on this end. All right. So if you'll speak with probation. All right. Yes.
Judge, we are here on a motion to set bond.
All right. So what's happening with the motion to revoke? Because this assault case, is that in Bexar County, the alleged assault?
Yes, it is, Your Honor.
All right. So what's going to be happening with that? And what's going to be happening with this case?
Judge, it's my understanding that the assault case is still in pre-file status, correct?
I do believe that, yes.
And your prosecutor has had an opportunity to start looking into the case.
Mm-hmm.
And it's my belief that we are working towards a global solution, which he will probably have authority over.
What I can add, Judge, is during the break, there was a video taken by a third party during this incident.
Mm-hmm.
In the video, it's not entirely clear if this is a mutual combat situation or if our client is acting in self-defense. Prosecutor showed it to us. We don't have a copy of it yet. At some point, what we'd like to do is walk through the video with our client and get a better sense of if she can provide a narrative for us as to what path are we going to take. Is this going to be a path where we might need a contested hearing? Or is this a position where we're going to engage in some sort of negotiation?
All right, Norma?
Yes, ma'am.
I need a reset date for 20 days for a contested MTR hearing, and then we'll address the bond issue.
July 30th.
All right, your contested hearing is going to be July 30th. Now let's move on to the bond.
Judge, if I may, we engaged with the prosecutor. She is providing a recommendation.
Okay.
Oh,
I have to call the case.
Yes, yes.
Okay. All right, the court is calling 2023 CR 8486 State versus Annabelle Marie Vela. Can I have parties announced?
Jones for the state.
Christopher Ramos and Paul Acevedo for the defense.
All right, and are you Miss Vela?
Yes.
All right, defense, you're requesting a bond?
Yes, Judge, we're asking the court to set a bond, please.
All right, and it appears that you're in agreement with the state for a bond amount of $10,000?
Subject to the court's approval, yes, Judge.
All right. And the $10,000 bond, that amount, what is it based upon?
Judge, the original bond, if I'm not mistaken, was set at 10,000. After she reviewed the profile, I think she felt it was appropriate that the bond be set at 10,000.
We can add, Judge, as well that as we spoke to probation, Mr. Acevedo spoke to probation. Apparently she's on track. Other than this alleged new number one, she's meeting all her criteria and all her goals. She's in compliance with probation.
So why is the bond at 10,000?
Your Honor, that was the original bond amount. It does appear after looking at this defendant's criminal history, there have been some assaultive issues in her past, although there have been no convictions that did, alert a red flag for the state. Additionally, she has had a couple supplemental reports throughout her period of probation. And so just due to that and the original bond amount and then picking up the offense, that is why the state recommended 10,000.
All right, what's her criminal history?
As I said, Your Honor,
Judge, right off the top of my head, I want to say This is her only serious offense that she's on probation for right now. And I could be wrong. But Chris, do you have a problem if she tells the judge what off the top of her head?
If the court wants to hear from her.
Sure, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Annabelle Bella.
All right. Do you have any criminal history?
Nothing that I was really convicted for. I was on deferred adjudication for a year, which I completed successfully. But I believe,
Well, the year that you were on deferred adjudication, what was that for?
I think it was for criminal mischief.
All right.
I believe it was long ago. I don't remember, probably like 10 years ago.
Have you had any felony convictions?
Just besides this DWI, this is what I'm on probation for currently. Other than that, would be my first serious conviction.
Okay.
And the state would agree with that.
So she doesn't have any other criminal history
No,
other than this?
correct, no convictions.
Probation? How was she doing on probation other than this alleged new number one?
According to she judge, different classes, her drug tests have all come back negative. No concerns at this point. From the NPR that was filed.
And then the assault, that's the alleged new number one. Does anyone know, were there any type of alleged physical injuries, or it's just a misdemeanor assault?
It is a misdemeanor assault at this point.
And I shouldn't say just, but it's a misdemeanor assault.
It's a misdemeanor assault, Your Honor.
Okay. All right, is there anything else?
Not from the state.
No, Judge.
Okay. One other thing from you, are you currently employed?
Yes, ma'am.
All right.
She has a good job at Amazon.
Okay.
She's in good standing with them. As I understand it, when she's released, she has a job waiting for her.
All right, and have you ever missed reporting to probation?
No, ma'am. And if I did, I would let my probation officer know ahead of time and we would just reschedule it. But I've always been in good communication with my probation officer, and that's only happened twice. But
All right,
everything
and-
else is on track.
And what are the chances of your having contact with this running sting? And I don't want to get into the facts of the case.
Judge,
How does she allegedly know this running sting person?
Judge, she is currently pregnant with this child.
They were in a relationship. She's describing to us they're no longer in a relationship. And she has no intention of maintaining a relationship. But of course, once a child is born, there will have to be some sort of.
All right, what's the possibility of her being in contact with him or?
Judge, I would like to believe that she is smart enough to refrain from reaching out to you. But affairs of the heart are awfully difficult to deal with. But she's looking for what type of guarantee can you give her that you're going to?
I can guarantee that I have no intentions of speaking to him, of being with him, of anything really, because, it's brought me to this point. And I don't want to be back at this point ever again.
All right, could I have some whiteout, please? Yes.
When are you due?
November.
And Judge, as we mentioned, she is expecting, I presume between now and November, when the due date is, she'll have a number of doctor's appointments that she'll have to attend. We just wanted to mention that to the court.
All right, so this is being recalled for a contested hearing. If it turns out it's not contested, just let probation know. For July 30th, the court is going to set the bond at $2,500. There's to be no contact with Ronnie, R-O-N-N-I, Steen, S-T-E-E-N. If you have any contact with him, you will have violated the conditions that this court has set for your bond. If he shows up at your house, your attorneys will tell you how you should proceed. And no contact means no phone calls, no emails, no letters, no contact through third parties. Do you understand?
Yes, sir.
All right, they'll give you a reset form. Just make sure you're here on time on July 30th.
Thank you.
Is there anything else from either side?
No, Judge.
When you're released from custody, if probation wants you to check in with them, make sure you check in with them.
Thank you.
All right, thank you.
Thank you, Judge.
You're welcome. You're welcome. Are you all ready to proceed?
We are, Judge. We have an agreed recommendation for the court.
All right, the court is calling 2024 CR 011865. How do you pronounce your first name?
Jane.
Jana Lynn.
Jana Lynn. Yes, we were going over that.
Can I have parties announced?
For the state.
Raymond Bell for the fence.
And are you Ms. Sotomayor?
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Janalen or Janalen
Jana Lynn.
Sotomayor, who was placed on deferred adjudication in 2024 CR 011865 for the offense of possession of a controlled substance, penalty group 1B, 4,200 grams on January 13th, 2025 for a term of 4 years. Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 17th day of April 2026 in Bexar County, Texas. Defendant Janelyn Rianne Cruz Sotomayor did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure. Violated condition number 2, on or about the 2nd day of December 2025 in Bexar County, Texas. The defendant Janelyn Rianne Cruz Sotomayor did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
State will waive the remainder.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, find you guilty, sentence you to 20 years in prison and up to $10,000 fine? Did you understand that?
Yes.
Knowing that, do you still want to plead true to violations 2 and 2?
Yes.
Court will find 2 and 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion, continue, alter, and amend for felony drug court participation in screen.
That's correct, Judge. My understanding is that if the court approves that, they'll do the screen while she's still in custody.
So I saw your reaction when I said that you're looking at 20 years in prison.
Yeah.
So here's the thing, you're in yellow because you're pregnant. This whole thing, the reaction you gave me, you should have been thinking about that before you violated conditions of probation. You understand? And I'm sure your attorney will tell you, but I'm going to tell you this. If you get revoked and if you're sent to prison for minimum will be 2 years, right? That would mean that you would be having your child in a criminal institution. And you know what would end up happening? Child Protective Services would come to whatever location. If it's at the prison, they'll come to the prison. If it's at the jail, they'll come to the jail. And you know what they will do? They will be waiting for you to deliver your child and they will take your child. And then a legal case will start. And in that legal case, they will want to terminate your parental rights. And your attorney will tell you, anytime there's a newborn baby, guess what? You have people lining up because they want to accept the newborn baby because they figure not too much damage has been done because the baby is a newborn. And they will come, they will adopt that baby. And because you're in custody, they will do what's called a fast track to terminate your parental rights. And the only thing that it will be, either you're going to sign your paperwork to relinquish your rights, or either they're going to go to court on a fast track and terminate your parental rights. And then if the person who adopts your child is not somebody you know, you will never know who your child is with. Do you understand?
Yes, ma'am.
So if you don't make changes, that's what's going to end up happening. Okay? So court is finding 2 and 2 true. The court is going to alter and amend conditions to the following. You're going to remain in custody. And in custody, there's going to be a referral to felony drug court. You need to be honest with them about your use. You understand?
Yes, ma'am.
And Ms. Abrams, do we need an updated TAP? I don't know if a TAP evaluation was ever done for her.
Yes.
All right, so they're going to do an updated TAP evaluation. All of this is going to take place in custody. Now, if something happens at the Bexar County Jail where they release you by mistake, which has happened before, let me just tell you right now, since today is Thursday, that would mean that they will release you by mistake by midnight. If that happens, you had better be in this court first thing Friday morning and say, hey, Judge, they released me by mistake so that we can correct that mistake. You understand?
Yes, ma'am. Oh, what time, like if they did, like what time would be?
Oh, we're not gonna be here at midnight, but you show up I tell you what, you're waiting outside at 8:30. Hey, Judge, do not get sidetracked. Do not go anywhere else. Because if you're using drugs, whatever you're drinking, eating, using, it's just like your child is doing it too.
Right.
And that's something else your attorney can tell you. He and I both have worked on CPS cases. We represented children. And when you have children who are born addicted to drugs, guess what? They go through withdrawals. The only thing is they don't understand why they're in pain. And when you go to the hospital to visit your client is just crying incessantly and they're trembling and the doctors are trying to give them something to take their edge off, and it's impacting their brain and their development. Okay. All right. If you need something, you need to let us know because we can't help you if you don't reach out. Okay.
Well, so far I did enlist for parenting classes. I've been going to other than that, like you already answered the question that I would remain in jail, so until being screened or so. I was gonna ask, what if they say I don't qualify for it?
Oh no, let me just tell you. Felony drug court will accept you. They will say you qualify. The only way they're going to do that is if you're dishonest with them and say, oh, I don't have a problem.
Okay.
Then I'm going to get a report and you know what it's going to say? It's going to say, she told us she didn't have a problem.
Okay.
And then you and I are going to have a conversation because I know you have a problem based upon the motion to revoke.
Mhm.
Okay.
Okay.
That's right.
And is this going to be your first child?
This is my second. My first one I couldn't keep because of the situation I was in. It was way worse than this. So with things that have been going well for me out there, I wanted to keep this one.
Okay.
So this would technically to me be my first kid.
All right. So here's the thing. You got to make your life better for the baby. All right.
Yes, ma'am.
And everything that you do, you need to ask yourself, is this helping my child? Is this good for my child, what I'm about to do? And if the answer is no, then you got to fight it and not do it. All right. Anytime you're thinking about using, is this good for my child? And if it helps you to think of, if you're using drugs, if it helps you to think of your baby in their crib smoking a joint, and you say, oh, let a baby smoke a joint, that will be you. If you're using it, you're letting a baby smoke a joint. If you're using meth, if you're using cocaine, just think about a baby in a crib doing meth and cocaine, and you say to yourself, who would be giving a baby meth and cocaine? That will be you. So don't do it, okay?
Yes, ma'am.
And if you feel like, I just can't stop it, it's going to happen, that's when you need to pick up the phone, go to an AA meeting or a sober support meeting and get help, and then come back and see me, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. All right, be careful.
The court is calling 2026 CR 001243 and 2026 CR 008774, State versus Theodore Ted Garcia. If I can have parties approach and announce for the record.
Joseph Garcia, the defendant, Your Honor.
Hello. And are you Mr. Garcia?
Yes, Your Honor.
How did you become named Theodore Ted Garcia? Who are you named after?
Well, I guess my mother wanted to name me after my father, but I'm not junior. Because my dad already had a son before me. He's a junior. Yes. I'm not even the third or anything. I'm just Theodore Ted Garcia.
Well, you're not just Theodore Ted Garcia. You are the Theodore Ted Garcia.
Thank you.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, sir.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Garcia, did you review the application for deferred adjudication? Did you understand it and sign it?
Yes, sir.
And the cause number ending in 74, did you review the waiver of indictment and reading of information and rights under Article 1.051 and 26.0 of the Code of Criminal Procedure with your attorney, did you understand it and sign it?
Yes, sir.
By entering a plea under that cause number, you're giving up your rights to have a grand jury review the evidence and make a decision on whether or not to indict your case. You're also giving up certain rights your attorney has. Namely, your attorney has the right to the passage of 2 days from the presentation of the information and the right to have 10 days to prepare for trial. Did you understand?
Yes, sir.
And did you understand by entering this plea, you're giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in that cause number?
I do, Your Honor.
Then in that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the indictment and information with your attorney? Did you understand it?
I did, Your Honor.
Counsel, do you waive the reading?
We do, Your Honor.
State in each cause number, are you proceeding on the indictment and information as presented?
We're waiting. There, but Judge, I do believe I subsequently filed a notice, but we would be proceeding on the underlying charges.
Any objections to the waivers?
No objection, Chair.
Mr. Garcia, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, you're charged with assault on a peace officer or judge. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. You're also charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
Yes, I do.
If you've reached a plea bargain agreement in this cause number, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
I do, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 10 years in the prison. In each cause number, the state is opposed to your applications. The cause numbers will run concurrently. It will also run concurrently with 2026 CC 010172, 2026 PF 04978. State will take in consideration 2026 CR 007233, 2026 CC 002338. And in the cause number ended in 74, there's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
I do, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge, just that the cause ending in 7-4 is the same, is the filed case number for the 2026 PF 04978 that it's to run concurrent.
Okay, thank you. And each cause number, did you see the review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I do.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Your Honor.
Then in each cause number to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Yes, Your Honor, state offer receipts exhibit 1 and all attachments under both causes.
No objections, Your Honor.
All right. And state, have you spoken with the complainant?
We have, Judge.
All right, thank you. You may be excused. Sure. And each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? You need to speak up, sir.
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you requesting a PSI and TAP evaluation?
The defendant, Your Honor, made application with the Veterans Treatment Program.
Ah, that's true. I'm sorry, could I have that back, please? I'm sorry. I do remember that now. All right, are you waiving PSI?
Yes, Your Honor.
Right. Anything you wish to say on behalf of your client?
Your Honor, I've known this young man for some time. And one thing is, with proper, good direction and a program such as the Veterans Program, he does well. I believe it's part PTSD, 100% disabled veteran. And with all these different variables, it seems to be a great safety net for him. And I believe that he will do well and comply with all the terms and conditions with this program.
All right, and it appears, Mr. Garcia, that many of your charges, and it doesn't excuse it, but it does give explanations. Many, if not all of your charges occur when you are intoxicated and there are other things going on with you. So which branch did you serve in?
Marine Corps, Your Honor.
All right. So I'm going to give you an opportunity, because this will probably be your first time with the Veterans Treatment Court, and they're willing to accept you and work with you, but you need to work the plan that they're giving you. Otherwise, if you are revoked and it comes back to me, you know, you're open up to the full range of punishment. Do you understand?
Yes, Your Honor.
All right.
Judge, I want to be transparent with the court.
Yes.
He has participated in the program. And he went through a brutal second round, whether they would even consider which.
Oh, no, see now,
The
steel trap is opening up. I do remember this, and they wanted him to do certain things before they would even reconsider accepting him.
And so he reached the point that they accepted him, but I wanted to be transparent with the court.
No,
I didn't want to.
I appreciate that, because then I would have called you back and I would have said, wait a minute.
Why didn't you say something?
Yeah. So I 100% remember it now. And I do remember conversations that were had with the state and with probation and with Herman from the VTC, saying that they will only accept you if you did certain things. So I'm sure they probably made him do a lot before they would even consider to see if you're serious.
Yes.
This is probably your last chance.
Yes.
Yes, Your Honor, I understand.
And nobody can help you if you don't want help and if you don't ask for it. You understand?
Yes, Your Honor.
All right. So I'm going to grant your application and give you the deferred adjudication in each case. But if you are back on a motion to revoke, you're looking at the full range of punishment.
I understand.
All right, and cause number 4-3, ending in 4-3, the court is going to grant your application State, what length of time are you requesting for deferred adjudication?
Thank you.
All right. It's going to be 10 years deferred adjudication, and I can tell you, I understand why the state is asking for the 10 years. But if you complete everything successfully and Veterans Treatment Court asks that your probation be terminated before the 10 years, of course, that can be considered. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. This is run concurrent with 2026 CC 010172. Taking consideration 2026 CR 007233, 2026 CC 002338. Field visits 1 time per month for 4 months. Referral to VTC, and the court will note that you've been accepted. There's to be 300 hours of community service restitution. Are you receiving any type of treatment currently?
No, Your Honor. Right now, it's VA hospital. That's
Okay. Do you live by yourself or with someone?
I live with my mother right now.
I'm with who?
My mother right now.
Okay. We're gonna do anger management in that case. And the court will deduct 100 hours of community service restitution upon completion of anger management. The remaining community service hours will be deducted at 1 hour for every sober support meeting completed. So you can either do the sober support meetings or you can work in the hot sun. Probation, is there anything else under that cost number?
One last matter, Your Honor.
Yes.
Being a 100% disabled vet, I don't know what employment well taken under those circumstances. I don't think it's that he wouldn't want to look for employment.
All right, so employment or probation, it's employment or SSI?
Thank you.
Sure. All right, and that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
Next, we're going to move on to 2026 CR 008774. All right, and that cause number, what is your relationship to the complainant?
She was my ex-girlfriend.
You don't have to have any contact with her. Do you understand?
I understand, Your Honor.
If you have contact with her, a motion to revoke will be filed. Do you understand?
I do, Your Honor.
All right, and that cause number, the court is going to sentence you to 10 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 30 days, no employment as a home health care provider with minors. This is to run concurrent with 2026 CR 001243. Field visits 1 time per month for 4 months, referral to VTC. There's to be 300 hours community service restitution. I'm going to require the BIPP course. Once that's completed, 100 hours will be deemed satisfied. The remaining hours will be deducted at 1 hour per sober support meeting. There's an affirmative finding of family violence. There's to be no contact with the complainant. Probation. Probation, is there anything else that's required? All right, and I'm sorry, $1,500 fine, that would be probated. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because it's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're
Thank you.
welcome. Thank you. All right, who's here on Isidro Sanchez? Probation, there's no application. All right. Are you Mr. Sanchez?
Yes, ma'am.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge would be waiving abandoning count one, proceeding solely on count two.
No objection.
Are you all proceeding on the deadly weapon allegation?
We'll be waiving that, Judge.
All right. Any objection?
No.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Oh,
Judge, you didn't call the.
oh, I didn't cause the cause number? I thought I had. It's a crazy day.
That's why I was like, okay, I guess we're going.
I guess we're going. All right, the court is calling 2026 CR 0034550 State versus Isidro Sanchez. Can I have parties announced?
Right, great with the state.
Warren Wolf for Mr. Sanchez.
And you're Mr. Sanchez.
Yes, ma'am.
All right. The court is finding that the state is in compliance with discovery. The state is proceeding on count two, waiving count one and waiving the deadly weapon allegation. Mr. Sanchez, with regards to the admonishments, you're charged with deadly conduct, discharging a firearm as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
You believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, I have.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 2 years in the prison. Did you understand that to be your plea?
Yes.
State defense?
Yes, Judge.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Judge.
All right, then to the offense in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer to say exhibit number one, including all attachments.
No objection.
All right, state, you may be excused.
Thank
You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Judge.
All right, the court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There is to be no contact with Timothy Hernandez. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Does this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, stop doing silly things. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
Thank you.
For us, I mean, it's just a plea deadline for today.
Ah,
So just make.
all right,
please on
Jose
Monday.
Trujillo, if you'll come forward. All right, I was recently made aware that your attorney is in a sentencing,
Yes.
so she's not gonna be able to be here because I think it's a long sentencing.
Yes.
Are you employed?
May I say some words real quick too?
Sure.
Okay, so I'm here
Is it a
today.
poem? What are you gonna say to me?
Your Honor,
It's-
it may not be in his best interest.
If you want to,
I'm in the verge of getting evicted and I can't pay my bond. And I'm in the verge of them sending out a warrant for my arrest. So I was gonna ask you here today. I'm willing to work. I worked all my life. I worked for VIA 8 months as a bus driver. I worked on my days off. I would sell Spectrum for one of my acquaintances that I knew that needed help.
Mhm.
So I've worked 30 days out of the week, 40 hours plus out of the week. I know what it's like to work. I'm here today to ask. I've been in house arrest for 3 months. I was incarcerated for 7 months. It's been 11 months and I have not seen Melis Christian in 11 months.
okay,
And I've emailed her, called her, no touch, no reach back, nothing. So
just give me 1 second, okay?
Yes, ma'am.
Just have a seat. Just give me 1 second. All right, the court is calling 2025 CR 014693 State versus Lawrence Williams. Can I have parties approach and announce for the record? All right, and are you Mr. Williams?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Williams, did you review the application for community supervision with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? You're gonna need to speak up so that. Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on the lesser included offense of assault on me.
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged, well, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, but to both.
Mr. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Threatened?
You think the plea?
Oh, no.
All right. So, let me try it again. Has anyone threatened you, coerced you, or forced you to accept this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 1 year in the Bexar County Jail. There's a $500 fine to be probated. The state recommends community supervision. Did you understand that to be your plea?
Yes.
State defense?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours of community service restitution, no contact with Juan Pablo Medina and Raul Ramirez, and anger management course. Did you understand those are recommendations from the state?
Yes.
And the court does not have to follow those recommendations.
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contact.
State, any evidence?
It offers states one an attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that the state will be presenting evidence today in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
Your Honor, he's been in 3 weeks and he's has no criminal history. And he's at great risk of losing his apartment and job. And we were asking the court to follow this.
All right. So here's the thing. If somebody doesn't belong at an apartment complex, you need to call manager, call the police. You can't do your own self-help thing.
He was looking at my daughter.
Well, still, I mean, that's why you pick up the phone, call the police.
I called the police several times, but they didn't do anything.
I mean, we did discuss that. It was his apartment, his property that was a circumstance that contributed to the plea agreement. But this is not the way he normally functions in life.
We help everybody out. It's really nice person.
Hey, you just have to call the police. Okay? Court is going to find you guilty, sentence you to 1 year in the Bexar County Jail, suspended and probated for 1 year, $500 fine, probated. Are you employed or no?
Yes.
Proof of employment within 30 days. No employment as a home health care provider or with minors. 150 hours community service restitution. I'm going to order anger management. Once the anger management course is completed, the community service hours will be deemed satisfied. There's to be no contact with Juan Pablo Medina and Raul Ramirez. Field visits 1 time per month for 1 month. Probation, is there anything else?
Reporting judge.
Regular reporting by Zoom or in person and regular UAs. Is there anything else you need from the court to be successful? I'm sorry?
That'll be it.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Sure, thank you.
You're welcome.
The seat, sir.
All right, Jose Trujillo,
Good, Your Honor.
and there are no applications?
No, yeah.
All right, the court is calling 2025 CR 014831 State versus Jose Trujillo. Can I have parties announced for the record?
Rick Pena for the state of Texas.
I'll report on Lorraine Efron for Mr. Trevino.
And are you Mr. Trujillo?
Yes, ma'am.
All right, so Mr. Trujillo, you had an attorney that was previously appointed to you. You asked that the court that you receive another court-appointed attorney. Is that correct?
Yes, ma'am.
All right, have you had time to speak with your 2 attorneys, Ms. Efron and Mr. Porter?
Yes, ma'am.
Do you need any more time to confer with them?
No, ma'am.
And defense, are you waiving notice?
We are.
Okay. Defense, have you received all discovery?
I have. Is there, do I need to fill out 2 and 10?
I'm sorry, what?
Do I need to fill out a 2 and 10 day notice?
All right, and Mr. Trujillo, the court is going to find that the state is in compliance with discovery. And I can just place it on the record.
Okay.
All right, Mr. Trujillo, do you understand that your attorney has a right to have 10 days expire once he is presented with the indictment to prepare for trial?
Yes, ma'am.
And do you understand that your attorney is waiving that right and he's asking that the court allow you or this case to proceed without the 10-day notice?
Yes, ma'am.
All right, do you have any objections to your counsel waiving the 10-day notice and proceeding with this case?
No, ma'am.
All right. I'm going to show you the true bill of indictment. Did you review that with your attorneys?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do.
State, are you proceeding on the indictment as presented?
You're not showing, we're proceeding on lesser included misdemeanor offense of assault causes bodily injury to family member as a class A misdemeanor.
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the lesser included offense of assault causing bodily injury to a family member. That's a class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state is calling the right for them. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah, I do.
Mr. Trujillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for one moment. Let me look at. All right. Did you review the plea bargaining page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 192 days in the Bexar County Jail. They're saying that that judgment will be satisfied. It's a $500 fine. There are no applications. The state is taking in consideration 2025 CC 016503. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition or be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
State defense is at the plea?
Yes, Your Honor.
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead?
No contest, Your Honor.
State any evidence?
Yes, Your Honor. At this time, state will all current evidence, case exhibit 1 with all attachments.
Judge, we're gonna not object to the evidence that shows the assault took place, but we will be objecting to any other evidence in there that shows maybe there was choking or cords or anything of that nature.
And let me see. All right, so I can see in the indictment, the state has agreed to remove the impeding of breathing or circulation.
Correct, Your Honor. If I can give a response, can,
Yes.
in theory, chokes without impeding with it.
Mhm.
Any facts that could go forward that would go to prove that misdemeanor assault took place rather than the assault choking the third victim.
All right, just one moment. I'm going to review the stipulations, but before I accept the stipulations into evidence, we'll discuss, have each party discuss what issues they have with the stips. So did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. This plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
God bless you.
Oh, thank you. God bless you too.